judge and now as Attorney General, I have always had great faith in the institutions of democratic government, but their strength depends on public trust. And public faith in government institutions can be quickly eroded. When our citizens don't feel like they have access to the work their government is doing, they cannot receive prompt answers to reasonable questions. Problems with access to public records have featured heavily in a number of high-profile controversies. And our governor, Kate Brown, made improving transparency one of the first pledges of her new administration. The benefits of a robust public records system, which favors transparency whenever possible, are enormous. Public records disclosures have shed light on the performance of various state tax credit programs, the extent of crude oil shipments by rail across Oregon, lead contamination in our water, and myriad other subjects of profound interest to Oregonians. Before you conclude that these reflect great success stories of our law in action, however, you should know in each of the cases that I am thinking about, here my office ultimately had to step in and order a public agency to take steps to comply with public records law. And those are hardly the only cases where that has been true. That's not to say that I'm unsympathetic to some very real difficulties that government entities face under the public records law. I'm very much aware that this law was written in 1973, when our workplaces did not have nearly the volume of electronic records that public bodies must deal with today. And I'm also well aware that the changes made to the law since 1973 have consisted almost entirely of creation of hundreds of additional exemptions, each working to make a new kind of record unavailable to the public. Sometimes this is appropriate. Many of you have worked with me in this building know that I'm a staunch advocate for personal privacy. And our government necessarily collects a lot of sensitive information about individuals. Public bodies have custody of student records of young people in our schools and universities, tax returns from wage earners in the state, financial information from recipients of public benefits, health information about patients, and other things that similarly deserve protection. The need to safeguard sensitive information, combined with the volume of records in the contemporary workplace, can make responding to public records requests even more difficult. But sadly, there are other reasons why disclosure of public records can be resisted by public bodies. It can be uncomfortable to disclose records related to a program that has not succeeded, for example. Leaders may face difficult questions about their engagement, their choices, or even the actions of their subordinates. Or they may be annoyed by a requester who seems inordinately interested in their activities for no discernible reason. Responding to public records requests can be expensive, time-intensive, and laborious, pulling individuals away from other very important tasks. This can be particularly true in our smaller cities, counties, and agencies. It is not always easy to embrace the principles of open government, but even though it can be hard, tough questions and interested constituents are simply part of the deal when it comes to running a democratic government. When I decided to take up the issue of public records reform, I knew that success would require hearing from stakeholders on all sides of the issue. So I decided to create what is now called the Attorney General's Public Records Task Force. I wanted this group to be bipartisan and bicameral from day one, and therefore especially grateful to my legislative task force members, Senators Lee Beyer and Jeff Cruz, and Representatives John Huffman and Thomas, for their time, their energy, and their proven commitment to this work. We also have members representing the Oregon newspaper publishers. That would be Jeb Levine, here today, publisher of the Minnesota Register. The Society of Professional Journalists, represented by former Oregonian investigative reporter Les Seitz until his recent retirement, and now by Nick Budnick of the Oregon Tribune. And the Oregon Association of Broadcasters, represented by Keith Shipman. Governor Brown's recently appointed government accountability attorney Emily Matazar represents the governor's office on the task force. We have reached out to Secretary Richardson's office to replace former Deputy Secretary of State Robert Taylor, who served on the group through the end of last year. Bill Lemon and Josh Nasby took turns representing the Judicial Department. And Michael Kron, my special counsel, has shared his views with me. On the local government side, the cities, special districts, and counties have been represented by Scott Nichols, Mark Landauer, and Rob Bobette, respectively. And Mr. Bobette is also here to speak today. Finally, Osberg's Jesse Ellis O'Brien and Betty Reynolds, who has also joined us today in presenting, have represented non-media public interests in the task force's meeting. This task force has been meeting for more of this task force proposes meaningful changes in 3 key areas. First, Senate Bill 481 addresses the amount of time public bodies have to respond to a records request. Current law has vague requirements that public bodies provide proper and reasonable access to records. This has led to drastic variation in response times across the state. Senate Bill 481 requires a public body to acknowledge the receipt of a public records request within 5 business days, as soon as reasonably possible, but no later than 10 business days later. The public body must either furnish the requested records or provide a written statement to the requester explaining why the public body needs additional time to process the request and providing a reasonable estimate of when the public records will be furnished. This bill includes important safety valves for our smaller offices, making clear that responding to a public records request should not impair the other necessary functions of that office by creating a staffing crisis. Second, Senate Bill 481 encourages a culture of transparent government by making a very strong policy statement in favor of Oregonians' access to their government and its records. Our public meetings law has a very strong policy statement that describes its purpose: make sure that Oregonians are aware of government decisions and the reasons for those decisions. This robust legislative message will help the judiciary honor our commitment to transparency whenever possible. Senate Bill 481 also encourages governments to embrace transparency by protecting government bodies and government employees when they disclose records. The bill creates immunity from suit when the government discloses information in a good faith attempt to comply with our disclosure laws. And it provides that any privileged information accidentally disclosed by a public body remains privileged so that it can't be used in court. Privileged information generally does not have to be disclosed, but disclosure can certainly happen when large public records requests ask for hundreds, thousands, or even hundreds of thousands of documents. Third, Senate Bill 481 begins to address the huge amount of exemptions that have accumulated within our statute since 1973. When the Public Records Law was initially enacted, it contained 55 exemptions from public disclosure. Now there are more than 500. Our task force convened a subgroup to look at this issue. After extensive debate, we realized that assessing the need for so many exemptions is a task most appropriately left to the legislative branch. But we believe that we can help the legislature start to address that issue by creating a comprehensive, user-friendly, electronic catalog of exemptions. Under Senate Bill 481, my office would be responsible for putting this catalog together, including not only the text of the various exemptions, but references to appellate court decisions and other guidance, along with a description of the kinds of public bodies and issues that a given exemption is likely to involve. Not only should this facilitate considered legislative review of these exemptions, but will provide a useful resource to members of the public and representatives of government in addressing their own public records issues. And I'm sure you know we already have a public records manual that is widely used that my office is responsible for updating every 2 years after the future session. I'm very proud of the suggestions that my office has developed with the guidance of the Public Records Law Reform Task Force. I recognize that there is more work to be done. Our task force heard a number of complaints about the sometimes high costs of obtaining public records, and that is an issue I expect the task force to take up after this legislative session. One of the issues that seems to drive costs and delays is the fact that our electronic systems, especially email, result in the creation of so many public records that they become very difficult to manage. I believe that problem can only be mitigated if we start building our future electronic systems with public access in mind. I like to refer to it as transparency by design. The governor's office has also introduced legislation proposing a public records advocate. A trusted, independent advocate is an idea that the members of this task force uniformly endorse as a way to help avoid misunderstandings and lower costs for both government and public records requesters. My office and other stakeholders are committed to working with the governor's office to ensure that we get the final bill right and commend her for her leadership on this. And of course, we're more than willing to provide whatever assistance we can as the legislature thinks about how to address the almost 45 years worth of disclosure exemptions that our law has accumulated. Given that it has taken 4 decades to get to this point, was in law school at the time, I hope it is not too surprising that Senate Bill 81 does not try to solve every problem in government. And it is my hope that this task force will continue our work and bring further proposals to your consideration in the future. But I firmly believe the bill makes